Hey, an employee pastes your product roadmap into a public AI tool, and developer ships AI generated code that nobody can trace. And maybe a departing executive is going to download all kinds of confidential research, and a vendor's contract allows it to retain your prompts. These sound like they're separate problems, but they're all part of the same thing. It exposes the same weakness, and we're going to talk about your legal liability issues and that attack surface that opens with a world-class expert right after this. Hello and welcome to another episode of CISO Tradecraft, the podcast that provides you with the information, knowledge, and wisdom to be a more effective cybersecurity leader. My name is G. Mark Hardy. I'm your host for today, and I have with me Lee Kim. Welcome to the show.
Thank you.
Well, I was reading your biography and I realized I could probably spend most of the show reading it. And so I'm pretty sure everybody's going to be impressed with your knowledge of things. But one of the things I did learn is what an AV preeminent peer review rated attorney is, which means that that's the highest peer rating standard that's out there. You've supported public policy initiatives, work with DHS and things like that, and just a wealth of knowledge. So I'm so glad to have you on board. But one of the things I've always been worried when I have a lawyer on the show, this is general education. This is not legal advice, okay? So I don't want anybody coming back and saying, you told us and things like that. But you've been a technologist, an attorney, a cybersecurity professional, policy. A little bit about your background. What brought you here and to do what you're doing today?
Well, I started out as a IT professional doing systems, database, network admin kind of stuff. But then I basically got tired of just simply getting yelled at by the customer. I was on the vendor side, and I decided to go to law school and apply my technical knowledge. Of course, back then, what I knew about opportunities for lawyers is that become an IP lawyer and you can leverage your technology background. So that is what I did. So I got through law school, passed the patent bar exam and the state bar, and got out there, practiced IP law for a number of years, and I quickly became the law firm's cyber privacy tech legal guru because no one else had that background. And so I did my stint for about over a decade practicing law, in those contexts, and ended up working as an SME, doing cyber privacy SME work, as well as being in-house counsel for a nonprofit. And where I am today is that I advise at the intersection of cyber privacy and law as a consultant. So that pretty much wraps it all into one. But in terms of how I actually made the transition, shall we say, in terms of lawyer to cyber privacy kind of expert, I have to say that was just a happenstance kind of thing in terms of getting involved with InfraGard and also collaborating with some colleagues of mine with the computer emergency response team out of SEI back in the day, and that shaped my career and what was to come.
Wow. So you've come a long way, and you've done a lot too, because you're one of the few people that I've encountered that really understands technology and law. And so because of that transition you'd made that you talked about, what have you seen that causes some security professionals to misunderstand legal professionals like attorneys? And then conversely, what do attorneys tend to misunderstand about cybersecurity professionals?
Well, security professionals sometimes think that law is just simply boilerplate and it's meaningless. Lawyers oftentimes don't necessarily understand technology, so they just assume that technology works. However, let me button this up by saying that I think that lawyers and CISOs, for example, are a lot more in common than they are apart in terms of how they think and how they process things, because security professionals tend to see analytically what's going on and also what's wrong with this picture. And lawyers do the same with their issue spotting and diagnostics from a legal perspective too. So it's not so far apart as you might think.
Interesting. Well, let's get into some of the content that I wanted to discuss today. And as you had mentioned, both from a cybersecurity professional, legal professional, if we're working on a company staff, we need to go ahead and protect the organization. Among other things, we like to say that cybersecurity is the business of revenue protection. And as a legal advisor, when you're talking to executives, you're going to give them advice, ideally, that's going to help them protect the assets that they have. And usually what we call those most important information assets in any organization are the crown jewels. And that could be things like patents, copyrights, trademarks, trade secrets, things such as that. However, those aren't easy data security classifications. They don't just jump right out and say, hey, I am this, I am that. So for a CISO who is not versed in the legal issues but has to protect all these different categories of information that represent crown jewels, how should the CISO be thinking about IP or intellectual property?
I think that they should think about IP or intellectual property as this first conceptually in terms of an understanding of what it is. Intellectual property is a term for a special kind of information, which of course relates to valuable information for your company. And many companies nowadays, in the modern world at least, are very much information based, if not solely information based, in terms of how they make money.
Mm-hmm.
So that's why IP, of course, is important, because it's a special kind of information that essentially gives companies a leg up. But in terms of understanding what IP is specifically within an organization, and I personally have spent many a time in terms of being in between the security team and the legal team, and it really is the business that actually helps us define and identify what IP is, because IP is generally business assets. So thankfully, the CISO does not need to go to law school or attend law lectures on what IP is, or listen to the lawyer about instruction in terms of what IP is. And the onus really is on the business to let us know really what the IP is in terms of the identification. And of course, if they need help, then legal helps them set the definitions for what is IP within the definition, what's proprietary in their organization, such as a trade secret or a patentable invention or confidential know-how, for example.
Right. So really, as I hear you saying, it's not up to the CISO to go ahead and try to categorize all these different pieces of data and information that's floating around, but rather it's the organization. Legal often helps in that. We'll be able to define and say these things need to be protected. Perhaps these not as much so. Because I think sometimes people believe that when you have any type of information that you're working on, oh, it's a trade secret, and because I marked it confidential. And I don't need a law school lecture or anything like that, but what's the difference between like an ordinary piece of confidential information, which could even include things like PHI, personal health information, that would be confidential, as PII and anything else, the categories out there, from something that's meaningfully a trade secret? Because if it's a trade secret, it falls under different legal protections, but also it should be protected different ways. So how do we know when something really kind of falls into that bucket?
Sure. In general terms, it's important actually for CISOs, as you noted, to understand what a trade secret is compared to other types of information, such as the personal data or some other proprietary information. So, in a nutshell, a trade secret is essentially a certain type of valuable information that the company has made at least reasonable efforts to keep secret, that's not generally known, that can't be readily ascertained through lawful means, and that is valuable in the company's hands and also valuable if leaked to the competitor. So, in a nutshell, that's what a trade secret is. It really is something that is, of course, as you look at the name, it absolutely has to be something that is uh, kept secret. And that's why it's very important for CISOs to understand that, because they help to operationalize security, and protecting that data in a very strict sense is very important for trade secret protection, actually.
Yeah, because the thing I found interesting about trade secrets is exactly what you said. You got to keep it secret. So the ultimate proverbial trade secret is a secret formula for Coca-Cola, which is stored in a vault surrounded by dogs with rabies and machine guns and landmines and everything else. But the reality is there's probably a number of professionals who are well trusted within the organization who have access to that information because somebody needs to do the ordering and they have to fill the bill and things like that. But let's take an example, not necessarily of that, because there have been cases where some employees have attempted to go ahead and sell the secret formula, and the recipient of that promptly called federal law enforcement, and that ended that one. But let's take a different example. Right. How about where companies say, hey, this is a trade secret, but pretty much anybody can access it if you're an employee, and the contractors still have access to it, and people might have it in their own personal accounts and things like that. At some point, does behavior undermine the nature of something being a trade secret, and someone could argue it's no longer a trade secret because pretty much everybody just left it laying around?
Well, my question to you would be, was it ever a trade secret despite a label or someone calling it that? The law, generally speaking, and each state generally has their own law about what a trade secret is. Even though there's a Uniform Trade Secrets Act, there's generally a state-specific implementation of that. And the question, of course, is, have you made reasonable efforts to safeguard that information? If it never was, despite it being marked confidential, but behavior-wise it's everywhere, then I think you might have a difficult time in court.
Yeah. And ultimately, that's really where it matters, is that if you're going to try to protect something, identify it, label it, go through the due diligence that can demonstrate that we have made real, genuine efforts to restrict access to just the people who need it in the circumstances that they need it, so that if somebody were to then extract it out of that protected environment, try to introduce it someplace else, you could make a very strong case that, no, this was not laying around. Somebody had to do some real efforts to go ahead and breach this. And so I think that's very, very good to understand. And so by working with legal, CISOs could go ahead and say, hey, information that we've decided is trade secrets needs special protection, which means you keep track of who had access to it, and you terminate access to things when they no longer have a business need. And in a perfect world, you'd also be able to prevent duplication and propagation of that, so it could only be used when it needs to be used. My example that I think for my military career is that on my first ship, I was among other collateral duties, a top secret control officer. So that's about as close as I think as you're going to get to trade secrets. And as a top secret control officer, any documents that were labeled top secret, I had to page count them. And anybody ever needed access to them, I had access to the safe. I had to get them to sign it. We'd count the pages. They'd do whatever they need to do in a very controlled place. They can't just walk around in the mess decks and eat a sandwich while they're working with it. When we're done, we'll count all the pages and put it all back in the safe and lock it back up. And so there are some very, very deliberate controls there. So that in the event that someone were to ever surface with something that was determined to be top secret, we could demonstrate through a chain of custody, through all the behaviors, that it was protected. And I think it's very, very similar to what we see in a corporation, which kind of brings up the question that these things don't just kind of wander off by themselves, particularly if there's some sort of securing, but employees may, out of a matter of convenience, I'm going to work it from home. I'm going to make a copy, or I'm going to put it on my hard drive, my cell phone, my laptop, and things like that, and things such as that. And now this potentially could lead to intellectual property loss, or because people feel they're entitled, or convenience and things like that. What do you do about that? And does that represent insider risk, or does it just represent bad behavior? And you correct those problems in different ways.
Absolutely. The real answer is it truly is all of the above. I mean, of course, insider threat is, sometimes it's malicious, sometimes it's negligent, and is there a lot of this that happens in terms of employees, contractors, and other trusted insiders walking away with valuable information? Unfortunately, yes. Is it typical for many companies not to even have a formal insider threat / insider risk program? You betcha. Many organizations, in fact, have a semi-formal, but it might not be consistently applied, enforced, including at all levels, etc. So there's that. But you should. I mean, it is a culmination with layering protections like a formal insider threat program, and of course, constantly revising it, and as incidents may occur, as you go through various events that may happen, refine it, and two, if something truly is a trade secret or proprietary, what you had mentioned, ensuring that something is, need to know, it's tracked, it's monitored. Maybe you have hopefully some kind of electronic vault system where you can really constrain who's able to check in and check out information, and in what formats are able to export information, if at all. I think that's truly, truly important. So much of it, I think, is a reflection on the organization's overall data governance, and in what shape is that program in addition to the insider risk. So it's not an easy answer, but I'd say the companies that fail are the ones that likely have pretty miserable governance principles in place.
No, I think that's good insight. And those are pretty easy to spot, I would think, kind of a lackadaisical approach toward how do we handle things that are very sensitive, and is there an existing system? Are there procedures? Are they followed? Are they audited? Are they validated? And does it become, most importantly, in my opinion anyway, part of your corporate culture? If it's part of your culture that you have a focus on, we're going to protect this, we're going to treat this thing a very certain way, then there's a respect that people have for the job that they're doing. And so if you're doing any type of activity that could involve, if this goes wrong, I could really get hurt. Now, probably not with intellectual property. No, as a private pilot, when I do a little walkthrough on an airplane, it's always like, yeah, I'm going to do this really carefully because I don't want this thing to die in mid-flight, and then all of a sudden I'm facing with a life or death situation. So you treat those every time with a lot of respect. It's when you have overconfidence and when you just walk in, oh yeah, I'll be fine, is where people make mistakes. Now,
That's
yeah. And so when people work with stuff, and during the course of a job, they're going to have access to all kinds of internal information, sensitive information, trade secrets, etc. But we don't have a little flashy thing like they have on the movies where it can make you forget everything. So when somebody leaves, we usually have part of the employment agreement is going to say you're going to turn over all paper copies or all electronic copies of all kinds of internal information. You leave the laptop behind. And for the most part, I think people are pretty good with doing that. I don't see a whole lot of people that are trying to be negative or break the law, etc. But in your mind, you still know how things work. You still know how the process works. You still know how things do. And you can't really divorce your brain from information that's already there. So once you leave a business on good terms and you've turned in all the paper document and things like that, and you go work for a different job someplace else, there's nothing really that's keeping you from saying, hey, I remember over there we used to turn this knob to the left instead of the right. It worked better. Is there anything that just says, well, yeah, you weren't really doing anything wrong when you just happen to have a good memory? Or do you have to kind of flashy thing yourself?
Well, I think that in general, the law respects people's knowledge, skills, and abilities, and things that they gain as a part of employment. On the other hand, when you think about IP, the question is, are you, let's say a person has a photographic memory, and they memorize the price list, right?
Mm-hmm.
For widgets that are made. And they set up a company with, making the same widgets, and maybe somehow or another, they also memorize the blueprints, and they undercut the pricing that supposedly they memorized. Well, that would be perhaps something that's a little bit more dangerous in terms of a court situation. Mm-hmm. However, if you know exactly how to adjust configurations and do something this way in terms of a skill and something as part of your profession, and notwithstanding anything messy like non-competes. I think that throughout the case law, throughout jurisprudence, you're generally welcome to exercise your knowledge, skills, and abilities. But on the other hand, if you're racing to the patent office to claim that you invented something, and so you're trying to be first to file for something that was secret, then I guess you would know. So I think that there's a little bit more of that flashy things you mentioned. It's certainly far different when a person is, for example, trying to file for patent protection for something they've worked on when they were, in the employ previously of a previous company, or when they're trying to register copyright in some source code that they just magically happen to remember. I think that these things are when it's maybe too coincidental that you're really trying to hurt your previous employer or company and, undermine competition. You're right, there's no bright line rule, but it's kind of apples and oranges. But it's safe to say if you are a skilled machinist or whatever the case may be, then generally you're welcome to be a skilled machinist.
Yeah. So let me ask you kind of a theoretical question here, because I'm not a lawyer and I don't play one on TV. But when I'm talking to people, they do startups. Oh, I got this brilliant idea, and do I patent it? Well, of course, if you do a patent, you have to disclose to a person with ordinary skill in the art how it works. So the exchange of a patent is in exchange for telling the world how it works. The legal system will protect you for some period of time, 20 years, whatever, that says, okay, you can have a monopoly use of your own knowledge, but your drug that you invented, when it clicks over and becomes quote unquote generic, it just simply means that that process is no longer protected by the law. It doesn't last forever. And now somebody else who did not incur all of that overhead, all the R, all the D, all of the marketing to create this thing out there, you flip it over to that. Okay, so with that kind of as a foundation, when someone comes up with really cool ideas, software or whatever, where they say, do I copyright it? Do I trademark it? Do I patent it? And things like that. My maybe cynical observation is the legal system is not going to help you against a rapacious big corporation who will just simply spend you into oblivion. You may be dead to rights to your invention, but a big company just simply say, okay, we can make $1 billion, so let's assign 50 million in lawyers. And eventually this person will cave because there's no way they could raise that much money, and will just stomp all over them. I've heard about that from time to time. Of course, we tend to think that hopefully that's not being trained in our business schools and certainly not in our law school classes. But when somebody is coming up with some new ideas, and there's all kinds of frontiers for new ideas, artificial intelligence is sort of the hot thing in 2026. Is it worthwhile doing all that paperwork and trying to file for a patent? And then I know when I've done patents and I've got patent filings, you kind of say, well, you do this, but then in this, and then this, and then all you put the claims out there until it claims the entire planet. Then hopefully they just narrow it back down again and said, okay, this is what you get. But what advice would you give to somebody who is coming up with some really great, brilliant ideas to say, is it speed to market that'll protect you? Is it the legal system that'll protect you when you're dealing with software and codes and things like that? And also recognizing that just doing it with the computer doesn't necessarily make it protectable.
Well, in terms of protecting your own invention, the first thing that I would want to know if I were in that position is, do you have any kind of work for hire kind of agreement where you may have already assigned away your rights? Mm-hmm. If that's the case, what does it cover? Does it cover work outside of your day-to-day job? Does it say anytime, anywhere? Does it say only in these fields? Does it say anything that you invent? There's a really broad spectrum in terms of that assignment. And of course, if you do have what you think is the next best thing, whether it's an improvement patent or a pioneering patent where no one else has ever, thought of this before, then absolutely, I would say see an IP attorney. And see if anything that you may have signed may take away any of those rights. But let's say on your own, you're just simply an independent inventor, probably the very best thing to do that I would say that where people should start off with is calling the United States Patent and Trademark Office, and they essentially have an inventor's assistance hotline for independent inventors. And there are, of course, some nonprofit organizations that specialize in representing independent inventors as well. But the bottom line is it's very important to keep that notebook in terms of, I conceived of this idea on this date, this time, because of X, Y, Z. Here was my idea, 1, 2, 3, as detailed as you can make it, so that if a year from now or 2 years from now or whatever it is, that it's not just simply written shorthand, so that you know exactly what your idea was, because sometimes people make that mistake in terms of the shortcuts. But the other thing too is in terms of things such as reduction to practice, because there's conception, right? Conceiving an idea, and then you reduce something to practice in some way, whether it's physical or constructive or otherwise. So then you have to detail the steps of, here's how I made attempts to reduce this to something that is workable with the intended objective. And these are my tests. That's where the results. And the best that you could do is your own details and specificity and ensuring that you keep a log. Now, in terms of litigation tactics and sometimes things that might be unfair, such as in the discovery phase, that's anyone's best guess. But there is one thing even before that that I wanted to just clear up for the record for everyone that's watching, which is to say patents are exclusionary rights. They are the right to exclude others from making, using, selling, or importing a claimed invention, as you know. So because those are exclusionary rights, the question then turns to, it's not just simply marking my invention as something patented or noting that on my website and I get in all this money and all the royalties. It really is the case that you have actually the financial wherewithal, shall we say, to actually fight other entities that may potentially infringe upon your invention. That's easier said than done. The same is true for copyright or any IP right, really. My IP law mentor, his saying is that you essentially have to understand that intellectual property itself is a shield and it's also a sword. And unless you can do both, it's not really worth much. So I'd say be ready. You had mentioned finances. Sorry, it's not just going to be $200 or $500 or
it's more than the filing fee.
Yeah, much more than the filing fee. There are layers and layers to this, and you also probably likely should do a patent search to see if anyone else has patented this, if it appears in published non-patent literature, and also if you might potentially be infringing on another claimed invention. You just never know, and essentially once you put your product out there, it's there, and you're kind of exposed, notwithstanding everything else that's going on in the world.
Yeah.
Anyway, a long-winded explanation about which essentially says be careful.
Yeah, and the other thing I think, as you'd mentioned, I think a very important point is the financial wherewithal. So some people are employees. They're like, oh, I came up with a great idea. I'm going to quit my business, go home, and build this thing in the garage and make $1 billion. Well, it doesn't happen that way. It takes an awful lot to mature that idea, as you said, reduce it to practice. It means you can't just say, well, I have an idea of creating a reusable rocket and we'll put men on Mars. Okay, but if you actually start doing that and you put things up into space and it comes back down and it lands and it floats, you could put it. Okay, that's something different. You can't just come up with a crazy idea. But the other thing also is this, is that you can't build your life around an idea. If you say, I got this one great idea and I'm going to go quit my job and go eat macaroni and cheese for 2 years, build in the garage, maybe that's going to work. But you might be better off working out something with your employer. And if you have an unfair deal where it says anything you've ever conceived of in the next 5 generations of your offspring, any place, anywhere, anytime. And like, yeah, no, that's ridiculous. And in some places, I'm pretty sure that would get thrown out of court. Just like in California, there's a jurisdiction that says, yeah, the non-competes don't work over there. And when people are told to have to sign a non-compete, I said, there's only one thing you want to change in the non-compete. Let them ask for anything they want and just put down this agreement will be enforced in the state of California. And at that point, you've just defused the entire thing. But enough about kind of the fun stuff. Let's go ahead and get into something that might be a little bit more current, which has to do with AI. And specifically with regard to, for those of us who are using AI to either write software, to come up and develop ideas and things such as that, maybe even writing books, writing cartoons, writing movies, scripts. I've seen all kinds of amazing stuff. And of course, it's going to get even more amazing. What is the legal situation right now if you use AI to create something? Does that void your ability to trademark, patent, or copyright it? Or do you have to share it with the AI company that created the model? How does that work?
Well, so the lawyerly approach to this is that in terms of intellectual property, let's first set the stage, so to speak, in
Okay.
terms of what these things are. We all have heard of these terms: copyright, patents, trademarks, all that stuff. But
Mm-hmm.
what exactly does that mean? So copyrights are original forms of expression
Mm-hmm.
that's fixed in a tangible medium of expression, generally speaking. So, in other words, if I were to say a sentence and it were never ever recorded, that may not be copyrightable.
Mm-hmm.
However, the very
Book.
fact that, for example,
Yeah.
yes,
Right.
exactly. So essentially, copyright can extend to anything that's original expression, which since the mid 80s also extends to, of course, computer software. Um, Copyright so far extends to human authorship and not machine authorship, unless, of course, the human has had significant involvement in essentially generating or making
Mm-hmm.
that original expression. Now, what might that change in the future? Maybe. Might it be the case that in the future, I'll call them out, the United States Patent and Trademark Office, Office of Policy and International Affairs, let's say that they got involved and they were like, well, maybe we should think about what AI kind of IP means, where patents, trademarks, and copyrights. Yes,
Mm-hmm.
USPTO is USPTO, but they actually advise the Copyright Office too. Notwithstanding that, that's copyright to date. In terms of patents, patents rest, of course, in terms of human inventorship. So the inventor must be human as opposed to a machine. But the USPTO has certainly been investigating and inquiring and meeting with stakeholders and having conversations around at what extent is an invention potentially patentable, especially as we move into a day and age where AI may beget AI.
Yeah.
So, this is a question that people are wrestling with, and our government is wrestling with, and others around the world are wrestling with. We don't know where that's going to end up, but I do know that, as we all know, there's a lot of discussion about AI and where that's going, and I think that we should trust that our lawmakers, policymakers, people with government agencies, that they are all aware of this and where things are headed. So it's a to be seen. Our understanding today may not equate to what's valid tomorrow.
Yeah, I work with a client up in the Washington, D.C. area. And as we've implemented AI and made tools available like Microsoft Copilot and the like, there had been a concern that if you're going to use this to create information products that we would consider to be proprietary, i.e., things you could copyright, is you have to be very, very cautious about your use of AI tools because, as you had indicated, AI can't hold a trademark, a patent, or a copyright. It has to be a human, at least for time, or a corporation could actually hold something like that.
Right.
And then it just changes. It's good for under 25 years instead of your life plus 70 if you're a copyright. But more to the point, what advice should we as CISOs, if not legals doing it, tell people as we roll out this AI tool to say what you should not be using it for if we wish to protect intellectual property rights for the stuff we create? Are there any clear guide rails? Is it still pretty fuzzy, or is there just some general guidance that we could offer?
I think that the devil, of course, is in the details. If, for example, the AI company offers an indemnification for, let's say, intellectual property infringement, where they essentially say, in good faith, we believe that what you might use using our engine to generate graphics, for example, or other things, will be lawful and non-infringing, but in case it's not, then we will indemnify you in case anyone goes after you. Then there's that. On the other hand, if you are dealing with an AI where you have no idea what the provenance is regarding the source materials, let's say the internet is scraped. I won't name names, but we all know that there are various lawsuits against these certain AI companies, and potentially scraping the internet without permission. And where does that end up? That's still being contemplated, I guess you could say. So that's an interesting question, but I would say that the key consideration, of course, is what is the provenance of the source materials? Is there transparency around what that is? If it's not and it's very opaque, then I would say, being a person that doesn't like to bet on many things at all, I would probably not be betting on something where it's very opaque.
Yeah, good point. Now, one of the things I also came up is that when you read into contracts, and I'm one of the people who like to look at the details. Most people don't, but I tend to kind of dig in. It's like, whoa, look at that one. But one of the interesting things that came out, and I'm not looking for necessarily a legal determination on this, but this is our observation. When you're using AI tools, you have a little chance. I know, for example, in ChatGPT, you could train the world or not train the world. And this is the paid license and things like that. You could do that with Microsoft Copilot. Keep our information here or use it to train the outside world. And I think a lot of people like to prefer that their intimate conversations, whether business intimate or personal, not be used to train the world. And so the best way to protect yourself, number one, is to make sure you're using a paid license, because that's usually going to be part of the terms and conditions. As we like to say, if you don't pay for the product, you are the product. And so that's more likely to be the case in the unpaid version. But the other thought is that in terms of feedback, most AI models sometimes will say, hey, did you like my response? Was it good or was it bad? Or here's two responses. Do you like one or two? Now, if I've selected keep my information private, and then I go through and I come out hold the big thing, and at the end it says, hey, do you like one or like two? Am I in trouble if I pick one of those two choices? Because my understanding of my read of it is that, oh, that's used to train the model. You just explicitly gave us permission to train the model for this entire conversation that we started way back when. Thank you very much. And so I've been advising people, don't tell the AI model that you did a good job or a bad job. Just say, hey, it's not a human. It doesn't need reassurance. It's a tool. But in giving that feedback, I'm pretty sure under the terms and conditions that you give that right away. I'm not asking for a reading of it. I'm just wondering, have you encountered that? Or is that just an urban myth?
Have I encountered that? Yeah, absolutely. And essentially it's just simply you're feeding the AI with intelligence.
Mm-hmm.
You're giving up that intelligence if you essentially react to it. And of course it needs to know necessarily what came before to see what's valid or what's coming after. So I think it's a very interesting reading in that we won't voluntarily train, but on the other hand, to what extent is information, even if we might not quote unquote train, many companies, however, do retain output for a limited amount of time for monitoring, for example, in terms of abuse and safety. And what does that look like, by the way? No one really knows,
Yeah, that's
right?
true. It's all new frontier. And
It is. So I think it's very nuanced. What I would like to say is, hmm, I this is actually one of my favorite examples, which is to say, uh, you know, as you know, Italy was one of the main countries, first countries really, where their privacy office essentially banned ChatGPT throughout the entire country because simply at the time it was deemed to not be implementing sufficient privacy controls, and some things weren't sufficiently transparent, at least according to the allegations. And because there were certain things remedied, then after that, we finally, even us in America, we got the option to actually opt out, right?
mm-hmm.
Because there was a time when we couldn't. Um, so sometimes what I like to say to clients and others is also let the market solve these problems, and sometimes regulators too, whether it's the FTC or the privacy guarantor, in various countries. I mean, Italy has been very proactive actually in terms of privacy protections as relates to processing of personal data. Very innovative, very progressive. That's just simply one country, but generally these problems or these issues tend to surface and get resolved over time.
Got it. Well, we're getting close to the end of the show, so I have I think one big remaining question is this. It has to do with incident response. Typically, if we find out that there is a breach, some attacker breaks into our system and steals a bunch of data, then we have a certain response we have to do. If there is somebody who's an insider threat who goes ahead and steals a bunch of data, we have something to do with it. But some of the concerns we have with is what you were addressing with these AI models, and not necessarily somebody using the AI model that we've reviewed the contract, we've vetted it, we've approved it, but what's called shadow AI, where someone just downloads some model, they upload a whole bunch of sensitive information into it, at which point we realize, yep, that's used to train the world. Okay, that's an incident. Anything that security and or legal should do in that first 24 hours, do you get a chance, almost like a ACH transfer, where you can reach out and pull it back if you do it fast enough? Or is it gone forever and the people who got it or the company got it said, ha ha, yeah, you can't have it back and we won't delete it?
I think it depends
Ah, you
on
finally said
what
it. The it depends. I was going to say we get into the entire show with a lawyer without the it depends, but we got it
you caught me.
42 minutes in.
Yes.
Okay, well done.
Yes, it absolutely depends, but I could say that the question is, if something is ongoing, can you stop it in its tracks? And also, what I've personally found in terms of when these incidents happen is sometimes not everyone on our teams are notified that something did happen,
Mm-hmm.
like the privacy officer, the security officer, even legal, because the contract isn't always clear about who gets notified and when.
Yeah.
So sometimes we're, of course, at a stage where we all need to essentially quickly set up our incident command system and debrief and figure out what's going on and stop the bleeding as quickly as we can if there's something, frankly, still going on. On the other hand, if your information got sent to some kind of company you never heard of halfway around the world, then I don't think you can get that back.
Yeah, I'm afraid it's probably true. And so you have to be very, very careful about that. And part of that is technical controls, part of it's training and culture, and also making sure that legal and the cybersecurity work together as a team, because I think we need to be very, very much aligned on this with regard to the new world of AI. So any last thoughts? Or are we ready to wrap up? Anything you didn't get a chance to say that you think everybody needs to know about?
My last thoughts, I'd say, is something that I think that we should at least briefly touch on, G. Mark, which is to say, lawyers aren't necessarily the enemy. We are here to work in partnership with the CISO, and we are ultimately enablers, to the extent that there's a lack of communication, like you had mentioned, between security and legal, it's time for us to educate each other and understand how we can enable each other for the sake of the business moving forward. Because if there's always conflict and disagreements, chances are it's because of a lack of education, hence understanding. So, there needs to be necessarily that culture instilled, as you had mentioned, so that we can work in collaboration as opposed to in conflict with everything, really.
I think that's wonderful advice. With that, let's close out. Lee Kim, thank you very much for being part of CISO Tradecraft. This has been really helpful for me, and I hope for everybody else out there. If it has been helpful for you and you're not already a subscriber, go ahead and subscribe to CISO Tradecraft on your favorite podcast channel or on YouTube. Don't forget, we have a LinkedIn presence where we also put out information there. We have a Substack newsletter. We do the best we can to help you out with your career and your knowledge to help you become a better cybersecurity leader. So thank you again. This is your host, G. Mark Hardy, and until next time, stay safe out there.